we also want to thank those who are listening to the recording later on. This will be available on our website and social media channels. So this morning's webinar is on legal guidance through this coronavirus crisis. And we are joined this morning by David Redgate, who is a commercial property law specialist from Girlings Solicitors, and David Morgan, who's an employment law specialist also from Girlings. And they're going to be covering topics like furlough, rent reviews, all sorts of topics related to legal guidance as of the information that we have today, which is Tuesday, the 7th of April. But before I hand over to them, I'm going to hand over to our Marketing and Communications Manager, Rachel Pillard, who is going to talk us through how this webinar will work, how the presentations will work, and how you can ask questions and join in the conversation. So Rachel, over to you.
Thank you, Lisa. So welcome everybody. It's great to see a fantastic turnout we have today. Before we start, you'll see at the bottom of your screen there are several buttons. One of them is a wave function, and I would ask if you could all just click that button so I know that you can all hear us. Oh yeah, we're getting quite a few waves. If you have any technical issues during the session, you'll notice that there is a chat button at the bottom of your screen. Now, if you need to contact us, that is a private message, so we could deal with any technical issues that you have. Thank you very much. If you want to take your waves off now, that would be lovely. Thank you. You'll also see that there is a button that says Q&A. Now, there are going to be, I'm sure, many questions. I have seen how many slides that we are going to be working our way through this morning, and I'm sure that there'll be some questions from a lot of that. If you have a question, you're currently on silence, but please type your question into the Q&A section. Lisa, at a point at the end of each presentation, will be able to read out those questions to both Davids for their feedback. If your question, they need a little bit more information from you, we can unmute you as well, so you could actually ask that question. But I think in the first instance, if you can put your Q&As into the Q&A button, Lisa will be able to read those out for both the Davids. The way that the session is going to run is that David Redgate will start with his presentation, then we'll stop for Q&A, and then David Morgan will do his presentation, we'll stop for Q&A, and any more questions at the end, we can go through those. A recording of the session will be on our website, and I will circulate the recording as well after the session to you via email. And we also have the slides from this session that we can circulate. So if you would prefer not to take notes, but just listen, then you can relax and just listen to what both Davids have to say. So David Redgate is going to take the first part of the presentation. Welcome, David.
Thank you.
And I'm going to be in charge of the slides. So I'm going to now share the screen and we will start working our way through those. David Morgan, if I could ask you to put your microphone on silent for now, and I shall do the same. And David, it's over to you.
Thank you. And welcome everyone. Thank you for attending. And so here we have the slides. So we've only really been able to prepare these at this point because it's been so fast moving. But I think we have a settled position now. That's a picture of me before 3 weeks of isolation. And now you see me as I am. So first of all, the government response. So we've got the Health Protection Coronavirus Business Closure England Regulations 2020, of which there are two. And they number every set of regulations. There's about 6 days between the two of them. So you can see that they've been updating the regulations and their response at quite a rapid pace. Now the schedules to the regulations set out which businesses are to close during the relevant period. At the moment, the relevant period is a 28-day period, which are considered essential and are to remain open. And then we have the Coronavirus Act 2020, and Section 82 there, it curtails the landlord's ability to take back possession of a commercial property. And then there's a brief review on the reliefs, business rates, hardship grants. I've listed there the business loans which the government are introducing, but I'm not going to discuss those because it doesn't really fall into my ambit. These are the regulations. So Schedule 1, Part 1, lists the business premises, and essentially these are the kind of eating and drinking establishments that are to close for the purposes of selling food or drink to be consumed on the premises. Of course, they can still produce food and deliver food, but they can't serve in the premises. Part 2 of that same schedule sets out what are really kind of gathering establishments, such as cinemas, theatres, nightclubs, that sort of thing, that have to close. And then we kind of have this grey in between of firms that don't have to close but are expected to, such as Girlings themselves. We've got a skeleton crew going in every so often. Now these restrictions are reviewed every 28 days. The first review will come along on the 18th of April, so not far away. I expect that they'll probably be extended, but we'll wait and see. As soon as the Secretary of State considers that the restrictions set out in the regulations are no longer necessary to prevent, protect against, control or provide public health service response to the incident or spread of infection in England with the coronavirus, the Secretary of State must publish a direction terminating the relevant period. Okay, so you know it's not going to go on indefinitely. And then paragraph 9 of Schedule 22 of the Act provides that a person commits an offence if the person fails without reasonable excuse to comply, and a person who breaches could face a summary conviction of a fine. So that's, I guess, possibly if you don't close your premises when you should really. It's unclear what the maximum level will be, as no guidance has been set, but there could be as much as £5,000. Okay, so non-essential businesses. On the 23rd of March, the government asked all non-essential businesses and premises to close as part of the stepping up its measures to prevent the spread of coronavirus. So that is kind of an ask. You don't have to do that, but of course, as you'll see on the high street, there's not many shoppers around. So I think a lot of shops and businesses have taken the decision to close in any case. And then on the 26th of March, the government introduced the Health Protection Coronavirus Business Closure England regulations, as I mentioned before, which lists in Schedule 3 the businesses that are to remain open. And on the next slide, it lists them all there. So I won't list them all, but I think we all know it's food retailers, petrol stations, post offices, banks, vets, that sort of thing. And so there's some guidance there on what employers need to know. Now, I'm not going to go through that in depth either, because maybe David will cover some of those things, and I think everyone knows what they are in any case. So let's move on. Okay, so business rates, grants, and reliefs. So some of this has been covered in a previous webinar on business rates, which you may have followed before. But just to summarise, the government has not changed the legislation or adopted new legislation in relation to business rates, but the government will reimburse local authorities that use the existing discretionary relief powers under Section 47 of the Local Government Finance Act. Individual local authorities will adopt a local scheme and determine individual cases in line with government guidance. So Canterbury Council is identifying those businesses that qualify for the retail discount with the aim of contacting every eligible business by the 9th of April. Any businesses that do not receive correspondence from the local authority before 9th of April are encouraged to contact the local authority to apply for their rates relief It's the company Civica that is arranging that for the local authority. They're trying to identify businesses on their names, but of course some businesses, their names give no indication of what the nature of the business is. So do watch out. If you've not heard and you're expecting to hear, then get in touch with those. Okay, so the expanded retail discount, it's a relief of 100% of business rates for 2020, 2021. There is an eligibility criteria, so properties that qualify are wholly or mainly used as shops, restaurants, cafes, drinking establishments, cinemas, live music venues, for assembly and leisure, or as hotels, guest boarding premises, self-catering accommodation. Now, properties where the business has closed temporarily as a result of government advice will be considered to be occupied for the purposes of that relief. There's also a nursery discount. That again is 100% relief for the current year. And that's for properties wholly or mainly being occupied by providers of Ofsted Early Years Register and wholly or mainly used for the provision of the Early Years Foundation stage. Grants are being given. There's a Small Business Grant Fund, which is a payment of £10,000. The eligibility is for properties which on the 11th of March were eligible for relief under the Small Business Rate Relief Scheme and were eligible for relief under the Rural Rate Relief Scheme. For retail, hospitality and leisure, there's a grant of £10,000. That's where the rateable value is up to and including £15,000, or a larger grant of £25,000 where the rateable value is over £15,000 but less than £51,000. So the criteria for eligibility is that the properties have a rateable value of less than £51,000 would have been eligible for a discount under the business rates expanded retail discount scheme and leisure grant. Now, this is probably the part that you've not come across before. So the impact on existing business lease terms. So there is nothing in the government regulations or acts which say that the tenant is to stop paying rent. There are continuing obligations that the tenant has to the landlord, which are to continue to pay rent, to repair the premises in accordance with the lease, to ensure the property if that's in the lease. We'll talk about those. We'll also talk about rent deposits, rent reviews and break clauses. So the continuing obligation to pay. A tenant's obligation to pay rent is usually suspended only where the premises is damaged or destroyed. And so I think most leases are drafted on that basis and would never have contemplated the situation we're in now. So tenants unfortunately still have to pay even if they can't open up their premises. Now, some people have asked if there's a force majeure clause in their lease. That is very uncommon. I don't think I've actually seen it in a lease. So unfortunately, that will not help. There is a common law principle of frustration. So where you can't perform your side of the lease covenants. Now that's proved to be almost impossible to apply to leases. So it's something that we could look at, but it's highly unlikely that that would help. So clearly paying rent is going to be difficult for many tenants. And if so, they should be seeking an amicable agreement with the landlords on rent suspension or reduction on the basis that it would put them in the best position to trade once restrictions are lifted and pay a full rent in the future. However, landlords are not obliged to act in good faith, and they're not obliged to reach any kind of agreement with their tenants. So if the landlord should agree to some sort of suspension or reduction, what are the options? So they're listed there: rent suspension, where the tenant pays no rent until a set date, and then full rent becomes payable again from that date. A temporary rent reduction, the tenant pays a reduced rent until a set date, and then the full rent becomes payable again from that date. A permanent rent reduction, which is less likely, but I guess if the economy changes permanently, then that might be what parties agree. So what is the best option? This will depend on the circumstances of both parties. In the case of a permanent rent reduction, the landlord must consider what the effects will be on rent reviews and on lease renewal. So they will not want to hamper themselves in those regards. So the drafting of any agreement would be critical there. How should the agreement be dealt with? So it's really important that whatever is agreed, it is fully recorded in writing and it's clear to both parties what they've agreed to. Ideally, that would be in a deed, but it could be in a memorandum. If the intention is that the rent is permanently reduced and the landlord does not want to recover the difference in rent, then a deed of variation is the best option to ensure that the reduction is fully effective. If the agreement is intended to be a temporary one, it should still be recorded in writing. Ideally in a deed or a letter signed by both parties, but if that's not possible, then in an email chain setting out the agreed terms and showing that both parties have agreed to it would be better than a verbal agreement. Any agreement on the terms of a temporary reduction suspension should be set out clearly. You should consider the following issues. So firstly, how long is it intended to last for? Consider a set date or clearly definable event, such as the lifting of this relevant period. Is the landlord expecting the tenant to repay the unpaid rent or shortfall in rent at a later date? That might be by one-off payment, or it might be in increased rent for a period until the tenant's caught up. But whatever is agreed, it needs to be made clear. Is interest to be payable on the outstanding rent? And if so, is that at the default rate or base rate? Now, all leases should set out what they are. So base rate is sometimes simply referred to as the interest rate in your lease, and that would typically be the base rate of a particular bank. And the default rate is usually kind of penalty rate on top, so an additional 4% is quite usual. So rent deposits. So many tenants will have paid a rent deposit to their landlord. Typically that could be 3 to 6 months of rent, but it could be more or less. If there is a rent deposit, the rent deposit deed will entitle the landlord to withdraw sums to cover unpaid rent. The landlord is to give notice to the tenant of this. The tenant will then have to top up the deposit up to that rent deposit figure that they started with. If an agreement for a rent reduction or suspension has been reached, it would be wise to also document that will interact with the rent deposit deed, so that both parties are clear on when unpaid rent can be withdrawn from the rent deposit and when the tenant needs to repay the deposit. Rent reviews. It is usual for the lease to state that time is not of the essence for a rent review. This means that the review can still be carried out after the review date has passed. So for some people, that rent review might be to take place at this time. The market rent for an open market rent review clause will be assessed as at the relevant review date. So there is no particular advantage or disadvantage in terms of agreeing or determining the annual rent or delaying. In fact, it probably may make sense to delay for just practical reasons. There are likely to be practical issues as valuers are unlikely to be able to attend the property in person, given the current restrictions. If the review takes place at a later date, the tenant will almost certainly be obliged under the lease to pay the difference between the rent being paid and the revised rent. If the review date falls during a period when a temporary reduction or suspension has been agreed, then it should be documented in the agreement as to whether any backdated rent increase, assuming there is an increase, is payable once the rent is agreed or determined. Okay, so repair, vandalism, insurance. The tenant's repair obligations will continue in full force. So for some tenants, if they have a lease of the whole building, then they most likely have a full repairing lease to repair the whole building. If you have a lease of part of the building, then it might be that your repairing obligations are to the interior. In addition to general ongoing maintenance, the tenant will be responsible for repairing any damage to the property caused directly by the actions of the tenant or by the tenant's failure to act by a breach of the terms of the insurance policy by the tenant. Tenant also includes employees. So any action or failure of any employee counts as an action or failure of the tenant. Landlords and tenants should liaise with each other and with the insurance company to make sure that all possible security measures are in place to safeguard the property, as properties are more likely to be vulnerable to vandalism and break-ins at this time. It's also important to make sure that the insurer is aware the property is empty, if it is, and any changes to the policy are made. And that's because policies are often invalidated by the property being empty for a prolonged period. The insurance companies see that as being a greater risk, the property being vacant. Break clauses. So it may be that some tenants have a break clause in their lease, which allow them to terminate the lease if that's what they need. It's worth reviewing the lease to see whether there is a break date coming up. Not all leases will contain a break clause. Some will have a break clause with a fixed break date or dates. Some will allow a tenant to break the lease at any time, although this is rare. Typically, a break clause will require the tenant to give the landlord 6 months' notice. So, it's of limited use here. Often the break clause will be personal to the original tenant. Most break clauses will be conditional on all rent being paid up to date. If the break date or dates for serving a break notice falls within a period when a rent reduction or suspension has been agreed and the tenant is likely to want to exercise the break, the agreement with the landlord will need to include a waiver or of that condition to allow the break to be effective. There may be practical points to consider in relation to serving a break notice. For example, whether it is known that the landlord will not be at the address for service, because the landlord does need to receive the notice. Whether the tenant is able to serve notice, the tenant may be ill, self-isolating. There might be a reduction in the postal service, although not at the moment. So the best approach is to contact the landlord and ask them to confirm in writing or by email what the best address for service would be. all known addresses should be served, and the notice also sent by email and fax if possible. And the reason for that is that the courts are likely to take favourably an approach where all possible methods have been used. That's if there's any dispute over the service of the notice. Okay, so forfeiture for non-payment of rent. Section 82 of the Coronavirus Act prohibits forfeiture of the lease for non-payment of rent. This doesn't mean that the rent doesn't have to be paid. It still has to be paid. It's just that the landlord cannot take proceedings to take back the premises if the rent is not paid. So current proceedings for possession, if there are any, are suspended until the 30th of June. New proceedings cannot be brought until the 30th of June. And landlords cannot exercise the common law remedy of peaceful re-entry. So essentially, there's nothing that can be done during this period. And it's only once the 30th of June comes along that a landlord can do anything to gain possession of the property for a failure of the tenant to pay rent. In the Act, it does say that service charge, buildings insurance, other payments due under the lease will be considered as rent for the purposes of the Act. Not all leases benefit from the protection. So mining leases, not really relevant here. Agricultural tenancies, short-term leases of 6 months or less are not covered, and electronic communication code leases. So that might be a lease of a telecom mast. They are not protected. The prohibition does not extend to forfeiture for other breaches of lease terms. So, for example, failure to pay rent, or if the tenant is insolvent, the landlord can still take possession. In practice, landlords may be frustrated by the reduced capacity of the courts. So in practice, you may find that you do have to wait until the 30th of June. Forfeiture for other reasons. Any claim based on other grounds is almost certain simply to be rejected or returned by the courts in practice. Landlords may still attempt to serve a formal notice depending on the nature of the actual breach in question and whether it's capable of remedy. Any current claims will be stayed over until a date after the 30th of June. During the height of the epidemic, it is expected that landlords will have to give their tenants a reasonable time to remedy a breach. Given the stay-at-home advice, social distancing, there are likely to be practical difficulties with getting contractors on site to make remedies. The courts are likely to take a tenant-friendly approach. This is likely to apply where the matter is urgent for safety reasons. Or less likely, I should say, to apply where the matter is urgent. There are likely to be practical difficulties due to disruption to court services, as I mentioned before. Okay, so the landlord's considerations. Landlords are not obliged to agree concessions. Not agreeing a concession may result in the tenant's insolvency. And we've heard some of those in the news recently. The courts are not likely to look favourably on landlords who have not been flexible. In order for that to be relevant, of course, there needs to be a court case. Consider accepting rent payments monthly rather than quarterly, and such measures to help the tenant afford to pay the rent. For leases where there is a service charge, the landlord still has to provide the services, such as insurance, where insurance is relevant. So insurance considerations, builders insurance, we've mentioned already. So landlord or tenant or whoever is responsible for the builders insurance should speak to the insurance company if the premises is likely to be empty for some time, to make sure it's covered. Business interruption cover. Now, some tenants may have this cover, and if so, it'd be worth making inquiries with the insurer that there might be an insurance payout if you cannot operate the business due to the lockdown. Loss of rent insurance. Now, often landlords will have loss of rent cover as a bolt-on to their buildings insurance. It's not yet clear if landlords can expect a payout in the current situation for loss of rent, but it's worth inquiring with the insurer. And so that brings to conclusion my slides. And so if there are any questions, I'll see if I can answer.
Okay, thank you, David. That's really helpful. And also thank you for those slides, because they're very thorough. And I think when we post those on the website, I think that will be really helpful. Just a first, I think we had a, Maxine, I can see your hand is waved, but I don't know whether that was from earlier or whether you have a question. So okay, that's fine. That's thank you. So there is one question here from Steve and Rachel. I don't have the list open in front of me. So Steve, I'll check where you're from, but I'll read out your question, which is most insurers, or your comment possibly, I'll just read this out. Most insurers have relaxed the policy condition concerning unoccupied premises due to the restriction placed by HMG on non-essential businesses. Most insurers have extended the period that premises may be left unattended to 90 days, subject to further review. Landlords and tenants should still be aware that they should take reasonable measures to secure the premises for the demise. I think that's just a comment there, David. I don't know if you want to respond to that.
Yes, all I would say is it's still worth just checking with individual insurance companies and put them on notice if a property is empty for a period.
Okay. And just to add that, Steve from Braddon's.
Right, thank you, Steve. Thank you, Rachel. Okay, and are there any other questions? You can either wave or type your question into the Q&A. The other thing I wanted to suggest is that if you're listening but you have to leave the call at any point, please do type a comment or question in, because we can cover those at the end. So if you want to listen to that bit later on, that's absolutely fine. And what I might do is suggest that we move on to David Morgan's presentation, so you can digest everything, but you can still type your questions in and we'll make note of those and come back to them at the end. Okay, so David Morgan, over to you.
Okay.
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 Yep.
Okay, so I'm going to talk about the employment aspects of the coronavirus crisis for the next few minutes. We're going to look at layoff as it's distinct from the government furlough scheme, and then we'll move on to sort of redundancy issues that businesses might face following the furlough period. So if we can move on to the next slide, thank you. So I'm going to got one slide on layoff. It's quite a rare thing for employers to have in their contract, but basically a layoff clause is a contractual right that the employer has, and it allows the employer to require employees not to perform work and not to be paid during the period of the layoff. Employees do receive statutory guarantee payments, and those are £29 a day. But one of the less enticing aspects of layoff is it can only last for 4 weeks before employees have a statutory right to claim a redundancy payment. As I said, it's quite rare for employers to have this clause in the contract. probably 95% of employment clauses don't have it. I suspect it will become much more common in the future following coronavirus, but it's very much like the force majeure contracts that David Redgate talked about in commercial leases. And there's no point in spending a lot of time on layoff because it's quite unlikely to be used while furlough is in effect. Employers aren't going to be able to claim furlough pay if they lay off employees because they're not going to be paying the employees. So therefore, why would an employee lay off an employee rather than put them on furlough? So the bulk of my talk is going to be about the furlough scheme. Unfortunately, we don't have any rules yet. Further guidance was published on Saturday, but we don't have any formal legislation setting out the scheme. I would be very surprised if the rules, when they are published, aren't along the lines of the guidance. I think the government would really shoot itself in the foot if it now tried to pull back from the promises it has made through the guidance. The problem we have is the guidance is brief in some areas and some matters such as holiday aren't mentioned at all. And things may change slightly when the rules are published. So my talk was updated yesterday, and it was accurate at yesterday, but this is a very fast moving area. We've seen 3 updates to the guidance in the last 2 weeks, and I wouldn't be surprised if we see some more later this week. So the objective of the furlough scheme, when it was first announced by the Chancellor, basically it was focused on the protection from or the prevention of redundancies. That's sort of been pulled away from because I think there were a lot of concerns in the first few days that if employees were placed on furlough, they couldn't then be made redundant when the furlough scheme ended. It's been confirmed that that's no longer the case, and the later guidance now mentions that the objective of the scheme is to support employers whose operations have been severely affected. And the advice to employees is the purpose of the scheme is to keep you on the payroll if your employer is unable to operate or has no work for you to do because of coronavirus. The basics of the scheme are it effectively guarantees 80% of a furloughed worker's salary up to a cap of £2,500 a year. So we're looking there at I think at an annual salary of around about £37,000 before we come away from this cap. So pretty much we can guarantee the pay of anybody below that sort of level of salary up to 80% and up to £2,500 a month. That's what the government will pay. Now, that doesn't mean employees have to be paid 80%. Employers can top up to 100% of salary if they want. And basically the way it works is that employers are going to furlough employees, confirm to HMRC they've been furloughed, put their details into the HMRC website, which we're assured is being developed at the moment and about which I don't have any further details. But you'll be able to reclaim the salary plus the employer's national insurance contributions, plus the minimum auto-enrolment pension contributions. And the scheme is going to run from the 1st of March until the end of May. One area of confusion I have come across is a lot of employers think the scheme runs from 3 months from the time they place a worker on furlough. It doesn't. At the moment, it's going to run from the 1st of March for a 3-month period until the end of May, and the government have an option to extend it at that point. Thank you, Rachel. So in terms of eligibility, an employee must have been registered on your PAYE payroll on the 28th of February. This is really to prevent abuse of the scheme, people putting family members perhaps on the payroll after the 28th of February and claiming furlough pay from them. So it's an anti-abuse measure. It has created some areas of unfairness where, say, for example, employees joined a company on the 1st of March. Obviously, this announcement wasn't made until late March, and there are some people who joined new employers in early March who are falling through the gaps, and there is no news about what's going to happen with those. It is open to any organisation, so it can be a charity, a business, anybody who has employees on a PAYE payroll, but do take care if your business receives public funding, because what the guidance says is if public funding continues during the coronavirus crisis, then employers will be expected to pay their employees as normal from those funds and not to furlough them. All types of contract are covered, full-time, part-time and 0 hours. And it's open to employees. In the first round of guidance, it said who were made redundant after the 28th of February and then rehired by their employer. So obviously some employers acted fairly promptly and made lots of people redundant in early February, in early March. And this scheme wasn't allowed until late March, but what the government is allowing employers to do is rehire those employees who were made redundant and put them on the furlough scheme in order to protect those jobs. I've underlined made redundant because at the time I wrote these slides last Friday, that was the case. It's no longer a requirement that redundancy is the reason for dismissal, and employers are now free to rehire employees who were dismissed for another reason, i.e. such as resignation. However, I would say to employers that if an employee resigned and their employment terminated in March, you need to be very cautious about rehiring them, because obviously then that may start another period of notice that could be quite considerable, and you need to consider that impact on your business going forward. Thank you. In terms of working, furlough employees cannot work at all for their employer. They can't work reduced hours and they can't work from home. They can't provide any services to the employer, or they can't do anything that would lead to the generation of income for their employer. You can ask them to do training, but that is all that they will be allowed to do if they are furloughed. They can work for another employer. So if you have a part-time worker who's working for somebody else already, that's absolutely fine. They can continue to work for that other employer while he's furloughed. And it was confirmed on Saturday in the latest guidance that employees who have been placed on furlough are allowed to seek other employment and can go to work for a new employer during the furlough period. So say, for example, you have an employee who is receiving 80% of their pay on furlough. There is nothing to prevent them going to get a job for, say, Tesco's and doing a bit of part-time delivery work to make their pay up to the 100%. And it's also fine to volunteer during the furlough period. But please don't volunteer for, don't allow them to volunteer for you, because that will then look like they're providing you with services, but absolutely nothing to stop them going to work for a charity or anything else during the furlough period. So furlough must be for a minimum of 3 weeks. And I've said you can probably rotate employees in and out of furlough. That's been confirmed that you can do that in the latest advice on Saturday. So where you have 2 employees doing the same job, but you only have sufficient work for one of those employees during the furlough period, you can operate a 3 weeks on, 3 weeks off system. You can't do that for less than 3 weeks, because 3 weeks is the minimum period for each furlough, but you can continue to rotate employees through that while the furlough is in place. Do be a little bit cautious. Because obviously if one of those employees becomes sick while they're in a period of work, you then have to call back an employee out of furlough before the furlough period is complete, and you would then have the expense of not being able to claim furlough pay for that employee who was called back before the 3-week period was over. And moving on. Calculation of furlough pay. So for salaried workers, basically what the employer will do is look at what salary they got paid at the end of February. And for workers with variable pay who work variable hours or work lots of overtime, the way the furlough pay is going to be calculated is it's going to be the higher of the same as the equivalent month in 2019, or the average pay over the last 12 months. Or if they've been employed for less than 12 months, it will be calculated on a pro rata basis by dividing the amount they've earned by the number of months they've earned. It was confirmed on the weekend that furlough pay will include contractual commissions and bonuses, but obviously it won't, only contractual payments. The belief is at the moment it won't include discretionary bonuses or discretionary commissions, and it doesn't include benefits such as health insurance or a car allowance or anything like that. For national minimum wage purposes, obviously a lot of furloughed workers may be paid at national minimum wage. Furloughed time is not working time, so the 80% contribution to their pay paid by the government, if that's passed on by the employer and the employer doesn't top up their wages, then that's not going to put the employer in breach of the national minimum wage regulations. The only exception to that is for employers who are required to do training while they're furloughed. That will count as working time. And if you have workers who are on national minimum wage, then you will need to top up those workers to 100% of salary or to the national minimum wage level while they are undertaking training. So in terms of top up, you can claim 80% of the usual pay from HMRC, and employers are free to top up usual pay. Now, employees have to agree to furlough. Furlough is subject to the usual laws about employment, and it's subject to the usual laws about contract. And where an employer is requiring an employee not to work, it's obliged to pay them, and it's obliged to pay them their usual wages. So employees don't have to agree a pay cut unless you're in the very fortunate position of being an employer with a layoff clause. My experience so far is that employees are accepting pay cuts and they are accepting the furlough scheme. They are taking a fairly wide view of this, and I've not seen much kickback from employees about being placed on furlough or indeed about taking the 80% of pay. In considering top up, do consider that. I think the general employee expectation is that they don't seem to be expecting employers to top up their wages to 100%. And you also need to consider, of course, that employees don't have the same costs at the moment. For me, I usually commute from Broadstairs to Ashford, and working at home is actually saving me around £250 a month at the moment. So there is this reduced costs. They may not have childcare costs, they may not have commuting costs, and of course nobody is indulging in social activity at the moment. So employees may be able to cope without 100% of their pay. We do have this issue that paying furloughed employees 100% might cause resentment in staff who are still required to work, because one is getting paid the same money to sit at home. And of course, on the other flip side of that coin, you do want to retain valued staff within the business, and paying them 100% at a time of crisis might show your appreciation for them and develop a great deal of loyalty between you and your staff. Holiday is an area where we are in a lot of uncertainty with these regulations. One thing that is certain is that holiday does accrue during the furlough period. So if furlough lasts for 3 months, employees are going to accrue 3 months holiday during that time. And the government have amended the working time regulations so as to make it so that employees don't have to take all of that accrued holiday in this year. Obviously, businesses will hopefully be very busy in the latter part of the year because there will be a lot of deferred meetings and a lot of deferred business going on. And the government recognise that, and employees will be allowed to defer holiday to next year to allow for that. However, what we're not sure on at the moment is, can employees take or be required to take holiday while they're furloughed? The guidance hasn't addressed this. Until a few days ago, ACAS said no. They've sort of very quietly retrenched from that position. And ACAS's position is now that employees will be able to request holiday while they're furloughed. As to whether employers can require employees to take holiday, ACAS is silent on that at the moment. Some very respected employment commentators are saying, yes, it may be possible. But the position is sort of reliant on law in non-holiday areas, and the position is very confused at the moment. So I think it would be a very brave employer at this time who required his workers to take holiday during the furlough period. There is some argument that you can't be furloughed and be on holiday at the same time. On the other hand, for example, term time teachers in schools, they're not required to work during the school holidays, and they can be required to take paid holiday during that time as well. So we're not very clear on this position, nor are we very clear on whether you would need to top up wages during a holiday period so employees receive their usual pay. Watch this space. So as I said before, this is something I think that has been a little bit lost in the furlough scheme, is that little line that the furlough scheme is subject to the usual employment law rules, it's subject to the usual laws of contract. And what the usual laws of contract say is the contract of employment can't be varied unless both parties consent to that variation, or there's a clause in the contract that allows that variation. So furlough doesn't change that, and furlough requires two variations to the contract of employment. It requires an agreement between the employer and the employee that the employer will be allowed not to require the employee to work, and the employee is required not to do that work. And it also requires the agreement to a temporary pay cut. Now, if you are fortunate to have a layoff clause, you do have a clause in the contract that allows the variation. If you don't have a layoff clause, you're going to need to get your employee's agreement to be furloughed. So you should consult with your employees. That can be as simple as having a quick chat with them, and you do need to obtain their consent to be furloughed. As I said, there's very little pushback from employees about this. Most people are accepting that they need to agree to this variation in order to preserve their long-term job prospects. If you were to impose a change without the consent of the employee, that's a unilateral change to the contract. It's potentially a breach of contract. If the employee doesn't consent to the 80% pay, that's potentially an unlawful deduction. And the upshot of this is if you force an employee to take furlough without their consent, potentially they could resign and claim constructive dismissal. I don't want to over-egg this pudding, because my experience so far with a number of employers and employees is that provided the employer doesn't push things too far and sticks to the government scheme, the employees are agreeing it by and large. The only time I've seen pushback is where the employer has tried to go and be more restrictive than the government scheme. So it's basically saying at the end of the government scheme, we want you to agree to lay off as well. If the government scheme ends and we still can't afford to pay you, we want you to agree to be laid off at that time. And those are the types of positions where employees have pushed back. But generally, if you act reasonably, my experience has been that employees are accepting this. One thing to be cautious of is if you do have more than 20 employees who are affected by the furlough proposition, and if the upshot is that they don't accept furlough, you will have to make them redundant. Then you engage the statutory requirements for collective consultation. So where an employer proposes that they may have to dismiss more than 20 employees in a 3-month period, they're obliged to notify the Secretary of State of that, and they're obliged to engage in collective consultation. What this means is obviously you have to fill out a form to notify the government that you are proposing that redundancies may take place. You also have to elect employee representatives to engage in that consultation. You've got to consult with those representatives with a view to reaching an agreement, and you have to consult with a statutory period of 30 days where there are between 20 and 100 employees, and 45 days if there are more than 100 employees. The legislation, as I've said, says that normal employment law applies during the furlough period and to the furlough period. So please be careful not to discriminate against anyone in selecting employees for a furlough. If you've got 5 employees and 2 of them are to be furloughed, please be cautious about who you select, and make sure there are no protected characteristics that you're inadvertently discriminating against them. It will be justified to perhaps select some disabled or pregnant employees for furlough because they are at a particularly high risk by remaining in the workforce. So it potentially, whilst selecting pregnant employees for furlough because they're pregnant is discrimination, you do have a defence to that because they are at a higher risk from coronavirus, and therefore it is entirely proportionate to select them from furlough in order to protect their health. Okay, so guidance on Saturday has now confirmed that employees must be notified in writing that they have been furloughed. We would previously recommend that you get this in writing anyway because it records the employee's consent to being furloughed. You must keep the record for 5 years. And what we're recommending is that after you've had a consultation with your employees, you then write to them to confirm the outcome of that consultation. Confirm that you've furloughed the employee further to your discussions. Confirm the reason for the furlough. Sometimes that's for financial reasons, and sometimes it's for health and safety reasons if the employer can't enforce a 2-metre social distancing period in the workplace. Confirm the period of the furlough, and most people here are simply saying it will be until either we call you back into work because work will be available, or until the end of the expiry of the furlough scheme. And of course, we don't know how long that's going to be yet because it may be extended. Do confirm that they shouldn't do any work for you at all while they're furloughed, and do get them to indicate their consent to being furloughed by either signing the letter and posting it back to you or emailing you to show that they consent to being furloughed. Moving on to redundancy. You know, there is, obviously it makes sense to furlough employees while you can claim that payback from the government. The furlough scheme is going to come to an end at some point, and businesses may not be in a position to take all of their employees back on at that time. The furlough scheme will allow you now to progress with the redundancy. So employees who have been furloughed don't have to return to work. And it was a worry in the early days of the scheme that the government, having paid all this money for workers, may require them to go back to work for a certain period of time. But do be aware that if you are going to make redundancies at the end of the furlough scheme, you still need to follow a fair procedure. Employment law continues in full force, so employees will still have the rights to bring a claim for unfair dismissal. So you still need to follow a fair redundancy procedure, and you still need to consult with the employees about any redundancy. Employees will be entitled to notice pay according to their contract or their statutory notice rights, and they will also be entitled to redundancy pay. And if you need to check an employee's redundancy pay, there's a very good calculator on the government website that you can search for. You put the employee's details in, and that website will confirm the redundancy pay that's payable. And do remember the statutory requirements about if you're going to be making more than 20 employees redundant. This is the final slide, and then it's really, you know, if the worst really did come to the worst, and what would happen to your employees if your business was to go into insolvency. Unfortunately, it's something that some employers may need to think about, and in a small business in particular, it's more akin to a family relationship than an employer-employee relationship sometimes. The answer to this is employees aren't left high and dry on the failure of a business. They do have some rights. It's being confirmed that an administrator will be able to access the furlough scheme and continue to furlough the employees for as long as that scheme lasts if the employer goes insolvent. And employees do also have entitlement to statutory payments for notice, redundancy pay and holiday pay. The National Insurance Fund will step in and make those statutory payments to employees if the employer doesn't have the cash to pay them. Just some handy resources for you to think here. We have, there is the government guidance on the coronavirus website. If you search coronavirus job retention scheme, that will give the government guidance for employers at the moment. The second web link there is guidance for employees, and it's also worth reading that page to see it from the employee's point of view. And ACAS have given some very good advice on coronavirus as well. Okay, so I think I can see we've got a few questions.
Brilliant. Brilliant. Thank you, David. Thank you so much. So there are a number of questions which I will read out. If you have to leave the call, like I said before, we will continue to go through these questions and you can listen to that bit later on. So I'm just going to take these in the order they were posted. So first one, can furloughed employees post on social media?
If they're posting on behalf of your business, I would say they have to be very cautious about that, because what they're going to be doing is actually providing services to you. If part of their job role normally is to post on your behalf on social media, essentially they're continuing to perform their job. So if it's part of their job already, or it's something they're doing that generates revenue for you, I would say no, you shouldn't allow them to post on social media. Of course, they're free to post on their own profiles. Their general rights to freedom of expression continue, but you shouldn't allow them to do anything that looks like they're providing services for you while they're furloughed.
Okay, thank you. I appreciate there might be some nuance there. So if there's any follow-up to that question, please feel free to post that in the Q&A. So next one, I have an employee on a 0 hours contract as they only work in university holidays. How do I approach this furlough pay for next month? This person would usually work throughout the Easter holidays. Do I take this to be 80% of the earnings in the same month last year, or 80% of an average of monthly wage last year? The former will be significantly higher than the latter.
If you take the higher of those two, so if the former is going to be higher, then that's the employee's entitlement to furlough pay. It's the higher of the same month last year or the average of the last 12 months.
Okay, thank you. Is it allowed to furlough an employee for 3 weeks, bring them back for 1 week, then furlough again? Yes,
that was confirmed on Saturday that's possible. 3 weeks is the minimum period that you can furlough them for. If you lay them off for less than that, it will be a layoff rather than a furlough, and you won't be entitled to claim the money back from HMRC. It must last a minimum of 3 weeks.
Okay, and just my own follow-up to that. So if you furlough for the 3 week minimum, then bring someone back for however long, and then you want to furlough them again, do you need to go through the same process you described?
I think you could. Do you mean in terms of obtaining consent?
Yes, in terms of obtaining consent and written.
I think I think what will probably happen now for employees who want to do this cycling of furlough is that you'll need to adjust the letter so that they consent to being furloughed for whatever period is notified them for the period that the scheme remains in place. Okay. And I just mentioned in the letter that you may be required to work for such period as we decide, and you may be furloughed again at a late, on a subsequent occasion while this scheme remains in force.
Okay, thank you. Next question. If you start the furlough process of an employee on the 1st of May, are they entitled to funds until the end of May, or do they get the full 3 months, i.e. then needs to be furloughed until the end of July?
As matters stand, the furlough scheme is running for a 3-month period from the 1st of March. So it's you would only be entitled to claim furlough pay from the government until the end of May as matters stand. It may be that that's extended, and you can then claim for however many more months the government extends it for. But no, at the moment, employees you're only entitled to claim furlough pay until the end of May.
Okay, my own follow-up question to that was just probably a bit of an annoying question, but I'm assuming, as we have been, we'll be given a lot more guidance in the coming days and weeks. But as it stands now, what would the answer be to if someone wants to put an employee on furlough, let's say mid-May, and there's not a minimum 3-week period?
Then you may. So
I'm sorry if that's annoying.
No, you may not be able to claim. Obviously, you would then be taking a gamble that the furlough scheme is going to be extended beyond the end of May, and we simply don't know where we are at the moment. I mean, hopefully everybody will be back in work by the end of May, and coronavirus will be, the peak will have passed. But yes, it has to. What we know at the moment is the scheme's going to run until the end of May. Furlough has to be for a minimum of 3 weeks. So once we get beyond the first week of May, you would be taking a gamble about, if you did furlough people, would you get the money back from the government? I'm not sure.
Okay, thank you. That's based on, of course, what we know now. Next question. We have a team of 7 staff, but no revenue and cancelled contracts. We started a huge industry response program effort before support was made available, but have no revenue to cover that. Is there any way we can get support to cover our staff costs?
Sorry, Kurt, I've lost the question. I was being able to read them on the screen and can't see.
Yeah,
could you repeat that,
let me just tell you what, I'm going to copy that over because that came in on the chat. I'm just going to copy the question over. I think I can do that.
Thank you.
Yeah, oh, you've got it. Okay. Do you have it, David? Or should I read it again?
Contracts. We started a huge industry program effort. I'm really not sure about that. The only support that I'm aware of to cover employees' wages at the moment is the coronavirus job retention scheme, and obviously that's not going to be in place until the end of April. That's the aim at the moment. In terms of, I mean, obviously there are grants available, there are business loans available. They're a little bit outside my expertise as an employment lawyer, but I do believe that there are other loans and things like that in place for small employers, which may help you cover your staff costs. But the coronavirus job retention scheme is the only scheme I'm aware of at the moment that actually directly reimburses you for that.
Okay, thank you. Next question. What is the position of agency provided temps who are on PAYE, the PAYE scheme of the agency, and whose assignments are terminated after the 28th of February due to COVID-19?
I think obviously it depends on their contract with the agency. The agency is the person who pays them, and therefore if they're on the PAYE scheme of the agency, it will be the agency who has to claim that money back from HMRC. So I think the temps will need to talk to the agency about the agency furloughing them, and then they will receive their money in accordance with, I imagine they're on variable pay, so it'll be the higher of the average or their month's pay last year.
Okay. What happens if an employee already has holiday days booked during the furlough period? Will those days not count as holiday, and those days booked then carried forward to once the furlough is over?
The answer to this is we don't know at the moment. We don't know if holiday can be taken during furlough. I think the opinion is drifting towards yes, as employment law stands, it may. But there's nothing in the guidance about holiday and how that interacts with the furlough scheme. So I think what I would advise at the moment is if the employee actually wants to take them as holiday, I wouldn't necessarily stop them from doing so. You may want to consider topping up their pay for holiday days, because if they don't take them in the furlough period, they're going to have to take them later in the year. And if they take them later in the year, you're going to have to pay 100% of their pay anyway. But I think whilst I would certainly advise against employers requiring employees to take holiday on certain days during furlough, I think if an employee wants to take holiday during furlough, I would tend to advise that you shouldn't necessarily stop them from doing that. And we will just have to wait and see as to whether they would count as holiday or whether they would carry forward when further guidance is published.
Okay, thank you. Next question. Can the indication for consent be accepted verbally for furlough of an employee following receipt of a letter?
Yes, I think so, although I would really advise against that, and I would advise you to get something in writing. You do have to notify the employee in writing that they are being placed on furlough. That is that is going to be a HMRC requirement. It's being confirmed in the guidance. So you do have to send them a letter. Do they have to sign the letter or confirm their consent to it? I'm not sure they do, but I think it would be, I would always advise you to get consent in writing in these sort of situations. You're asking the employee to make a very big change to their contract of employment by taking a 20% pay cut for several months, and I would always advise you to get that confirmed in writing.
And this is just my follow-up. So if a lot of people don't have access to printers at home, things like that, would a handwritten letter that is then, I don't know, would that be acceptable?
Or an email, or if push came to shove, even a text message, anything in writing. Obviously, ideally, they'll basically email you back to say, I confirm I consent to the changes, to being furloughed. But if it's, handwritten note, anything in writing, I would be happier with than verbal consent.
Okay. And can I, last question that I see posted here, I'm just going, it's a follow-up to the question about the person who works on Easter holidays. So I should clarify, for the month of March last year, the earnings were 0, as for the majority of months throughout the year, with the exception of April, June, July, and December. So the average wage, about 200 per month over 3 months, would be the higher amount cumulatively. Salary paid last April was 450, so cumulatively over a 3-month period would be a total of 450, as nothing was earned in March or May.
Okay, basically how the HMR scheme is going to work hasn't been published yet. What the guidance says is that you should pay him either the higher of his equivalent salary for the months last year or the average earnings over the last 12 months. So I think for April's pay, I think you're going to do a separate calculation for April's pay, and you're going to do a separate calculation for March and May's pay. And on each of those pays, you're going to see what you can claim from the government. I think by the time the scheme is in place, the rules will probably be clearer, and we'll know more about that. But I think you calculate it on a month-to-month basis and give him the higher of the figures you come up with, and I think there's potentially a hidden benefit for your employee there.
Okay, thank you very much. I don't see any more questions on the Q&A or the chat, and I'm aware we are over time. So thank you to David and David very much, and thank you, Rachel, for managing all of this for us. As a business improvement district, we are continuing to run webinars. The ones we have run are on our website. So as David mentioned, the business rates, business support, this one will be as well. We also did one with Produced in Kent and Digital Beans on free digital support available for businesses who continue to operate now. We've also been getting together with different groups of businesses, so hoteliers, the Canterbury Culture Group, and we're looking at one with the evening and nighttime economy and retailers. So if any of you would like a different kinds of group, then please let me know. David, you also were just mentioning that there is a discount available through Girlings. Could you just comment on that?
Yeah, thanks, Lisa. During the COVID crisis, any member of BID will be entitled to a 15% discount with Girlings if they instruct us on a commercial or employment type matter or a litigation matter, and we're going to offer that 15% discount on our fees for however long the COVID crisis goes on for.
That's great. Thank you very much for that. And that is included, that information and that discount, on our website. And we'll put that in a follow-up email when we circulate the link to this. So, and we're also communicating with businesses in a number of ways, because we know that some of you aren't able to use your work email addresses. So we're communicating through different networks and groups like the King's Mile Traders Association, the Cathedral Quarter, and also the newly forming Castle Quarter area. So really trying to communicate with you in as many ways as we can, but keep an eye on the BID website and social media channels. And thank you very much, David Redgate and David Morgan. Thank you also for that discount that you're offering. And we look forward to being in touch. Oh, sorry, there's one last question. If I could squeeze, no, sorry, I can't see that. Rachel, go. Were you going to say something?
No, it was just Rosie saying thank you very much.
Right, okay. Thank you to everyone for joining us, and we look forward to being in touch in future Zoom or any kind of webinar sessions. And we hope you all have a good day. Thank you.
Thank you.
Thank you.